ETLE. Hussein, please take it away.
Thank you all for still being in the conference hall with us. I know that you're probably tired, hungry, you have low blood sugar. I'm suffering from the same malaise. However, I hope our session is going to give you a little bit of a dopamine rush, and we're going to keep it interesting for you. I know we're the last thing standing between you and lunch, so do bear with us. We're joined here today on the stage by Mr. John Kinton, Chief Legal Officer of Access Advance, Matteo Sabatini, Executive Advisor, Government Affairs, CISVEL, Uta Schneider, Vice President, Global Government Affairs, Avanci, and online we're joined by Dan McCurdy, Chief Executive Officer of RPX Corporation. Yes, I can see Dan on my screen. Hi, Dan. Thank you for joining us. I know there's a time difference. Much appreciated. I was planning on doing a little bit of a rapid-fire introduction round across all the panelists to ask them to tell us a little bit about their companies and their priorities. But I will skip that if that's okay for the speakers, in the interest of time and in the interest of keeping things lively and active. If that's okay, I'm just going to jump in right through with the first question. And if you would like to, please feel free to chime in all of the questions, and let's make it interactive. And I look forward to the audience questions as well. Just before we do that, I'm going to give a little bit of an intro to set the tone. As we know, patent pools help cut down transaction costs, streamline licensing negotiations, and they often contribute to price transparency in the SEP field. Some people might dispute that, as we have heard earlier today and in some of the panels yesterday. I do remember there was even a time when patent pools were hailed as the solution to all ills in the SEP field, and now there seems to be an underlying tone of some people appearing disillusioned with the solutions put forward by patent pools. At the same time, as we have heard yesterday and today, there is growing regulatory attention in the SEP field. We have just heard, for example, about the new draft tech transfer guidelines of the European Commission, which for the first time ever talks about the pro-competitive effects of licensing negotiation groups, as if they're meant to be a counterbalance to patent pools. This comes on the heels of the embattled SEP regulation, which the European Commission ended up withdrawing due to lack of viable political consensus. And at the same time, SEP litigation has seen an uptick in some jurisdictions, all of which directly affect patent pools and the landscape within which group licensing takes place. So on that note, I'm going to move directly to Uta and ask the first question. When I was preparing for the panel, I did a little bit of background research, and I found this quote on the media attributed to Uta, where she said in a previous panel, in a previous occasion, "I fail to understand why licensing negotiation groups are needed. There would be no situation in which an LNG would need to be involved in a pool licensing negotiation." Now, the European Commission came up with an answer to Uta's question of why, and they allege that LNGs can facilitate technology licensing by reducing licensing transaction costs, promoting more informed negotiations, and addressing a first-mover disadvantage, and I quote, "namely where technology implementers are unwilling to negotiate a technology transfer agreement before their competitors have done so." So, Uta, let's kick it off. Do you still stand by your earlier statement?
Well, in the interest of time, I can be very quick and just say yes. I still stand by that statement because, and I have to preface this by saying that I'm not a competition lawyer. I'm not even a lawyer. Though I did have constitutional law, German constitutional law as my minor, but I don't think that the Article 19, paragraph 4 of the German Constitution, the right to resist, is very pertinent to SEP licensing. So I look at SEP licensing more from a practical point of view. I work for Avanci. We are an independent intermediary that works with prospective licensors and prospective licensees to find a simple and efficient way to share technologies across or between different industry sectors. And basically, you could say that we follow a market-driven approach. We don't fully launch a program until we have actually found acceptance of a set of licensing terms and conditions, both by licensors as well as licensees. And our objective is always to provide a one-stop shop, meaning that we would like at the very least to have a critical mass of licensors and a critical mass of licensees that would accept our licensing terms and conditions for a joint license. And ideally, we want to have 100% on both sides. That is what we want. So if I look again at what LNGs are supposed to achieve, reduce, oh God, shit, I can't really read my notes. So reduce the number of individual negotiations. I mean, Avanci clearly does that. If you look, for example, at the Avanci 5G vehicle program, there we have now, which was launched in 2023, we have more than 80 licensors who participate in that program. And at the same time as of status today, we have already more than 60 automotive brands licensed. Our Avanci 4G vehicle program, which was launched back in 2017, there we have more than 110 automotive brands licensed to the portfolios, SEP portfolios of more than 60 licensors. In total, we have more than 225 connected vehicles under license. So reducing individual negotiations, check. We already do that. Reducing transaction cost, again, that's a quite easy answer because, yes, of course we do that. I would say it is a lot more simple and efficient to sign one license agreement instead of more than 80. For example, pooling of expertise, yes, I think we do that as well. The Avanci team has decades and decades of experience in various areas of SEP licensing, and of course also in our discussions with various licensors as well as licensees, we spend a lot of time and effort also educating various companies about SEP licensing, how it works, and what exactly the benefits of joint licensing via a licensing platform like Avanci are. And the first mover disadvantage, I mean, again, we only fully launch a program once we have acceptance on both sides. So we already have the first mover. And as more and more licensees decide to take an Avanci license, over the time we manage to establish a global level playing field where, no matter how small or large a company you are, no matter where in the world you're headquartered, you can get a license on the same terms and conditions as your competitors. So yes, I stand by what I said.
Thanks, Uta. I see that Matteo wants to chime in here, so please go ahead, Matteo.
Love to. So first of all, thank you for having me. Thank you, Hussein. Thank you, Andres, Nina, and all the team. This has been a phenomenal event. Just to settle expectation, likewise, I'm not a lawyer. I come to the patent space from the engineering side, and being in a room full of lawyers and judges, I just want to settle the expectations. So going back to what we discussed in these few days, I think there is one thing that sort of stuck in my mind as something that we've not discussed. We've talked quite a bit about the dangers of high royalty rate. What if we get, at the top of the friend rate? What if we get above the friend rate? What are the dangers there? And I think we all agree that there are dangers there. But we haven't talked about the opposite. What if we actually go too low with the royalty rate? What happens if we go to the bottom of the friend rate or even below friend rate? What are the effects on innovation? And I think we can also agree that if that's the case, then we really are taking away incentives to participate in the standardization process. So we also need to be careful about that. And so back to LNGs, the danger that I see, especially when transparent patent pools are available that offer friend rates and offer friend rates to the whole market, and LNG, especially the way that has been proposed by the Commissioner of the Bundeskartellamt, becomes dangerous because the objective is to decrease the royalty rate. And therefore, the risk is that that becomes a race to the bottom. And I think that there are, some of the assumptions that the Commission made are fairly misguided. For example, an LNG is not a joint purchasing group, because in a joint purchasing group, if there is no agreement on the price, there is no transaction. In the SEP licensing case, the good has been already transacted in the sense that the patents can be freely used by the members of the LNG even before a price has been agreed on. And they can be continued to be used while negotiations are ongoing or even litigation are ongoing. There's this idea that LNGs are the parallel of a pool. It's also a misguided assumption because pools include companies that are non-competing in the market of licensing SEPs, while LNGs de facto are including competitors. The market definition, as the panel before highlighted, is also quite misguided. If you look at how the ALNG in the guidance letter defines, at least that comfort letter defines the market for connectivity, it basically bulks everything together. And the result, first of all, I fail to see how a connected car can compete with a cell phone or with a smart meter. And on top of that, if you do that virtually, the whole IoT space, if you take away cell phones, which represent the bulk of the connectivity market, if you take away those, then any combination of manufacturer or of non-cell phones connected device will basically pass that test of being below the 15%. And that's an incredible danger. The last thing that I will say, another difference between patent pools and LNGs, patent pools have an incentive to close a license that is market-driven. And if the rates are not market-driven, they're not accepted, then they need to adjust. On the other hand, an LNG, I don't see what the incentive is to conclude a license because, again, the members of the LNG are already using the technology and the patents.
Thanks, Mateusz. I mean, since we're on this issue, I'm looking at John, if he would like to chime in as well before I turn to Dan.
I don't think I have much more to add than what the other two speakers said, other than I don't think an LNG is a complement to a pool. I think they're two very different concepts. Although on the surface they may appear that way, when you dig down, they're just not.
Thank you. Dan, if I may turn to you now, as we have heard a bit from Uta and the others about LNGs, I want to ask you a rather direct question. Now, I know that RPX does not consider itself an LNG, but more as a licensing aggregator, yet the distinction is lost on some people sometimes. So, after all, you've successfully negotiated group licensing deals for your clients, having spent a few billions of dollars acquiring patent rights. You facilitated one deal with Sysvel, if I'm not wrong, in 2019 in the Wi-Fi space. And last year, a deal was done between 16 RPX members and Sysvel under its video coding licensing program. So could you tell us a bit about what you think sets RPX apart from an LNG and what RPX's position is on LNGs?
Sure, and again, I apologize for not being able to be there in person. I had certainly hoped and tried to be there, but my schedule just wouldn't allow it. So let me start by saying that RPX supports all efforts to make the licensing of patents more efficient. We can just begin with that. Inefficiencies, as we all know, distract operating companies from delivering products and services to societies, and they divert funds from inventors and patent owners to entities that are needed to enforce patents, such as law firms and litigation funders. This leaves patent holders with only a very small fraction of licensing fees that are finally obtained. That reality is inconsistent, in our view, with the fundamental purpose of patent systems, which is, as we all know, to reward innovation. So, in the 17 years since RPX was formed, we have learned that there are significant efficiencies to be realized in solving a patent dispute that impacts many companies through a single transaction rather than each of those individuals trying to resolve the dispute on their own. No doubt that has to be a motivation of LNGs. As you just mentioned, RPX has spent more than $5.5 billion since our formation to acquire rights that mitigate patent risks for our members. And one thing I can assure you of is our biggest learning is that the concept of aggregating patent resolutions is much simpler than the extremely complex actions required to achieve them. Patent pools aggregate licensors. RPX aggregates licensees. So just for an example, let me give you a hypothetical licensing campaign where there are 20 patent owners in a SEP pool, and let's assume there are 20 key potential licensees to those SEPs. Obviously, there'll be more, but let's assume there's 20 key potential licensees. If each of those patent owners individually pursued each of the 20 key licensees, and there was a litigation for each one of them, that would be 400 litigations. So let's assume extremely conservatively that each litigation costs each side $3 million. And some litigations, as we all know, cost more than $20 million in just legal and financing fees. At the lowest estimate, that licensing campaign would cost $2.4 billion, excluding any royalties or licensing fees that were finally awarded. But if a patent pool can aggregate a portfolio from many patent owners, and if an entity aggregating interest from licensees can assemble a single transaction that satisfies each patent owner in the pool, not easy, and each implementer, also not easy, then licensing costs could potentially be reduced by more than 90%. In other words, from $2.4 billion plus licensing fees to maybe $300 million or less in total costs and licensing fees. That's efficiency. And the savings are realized by, obviously, eliminating the costs that are inherent in protracted licensing discussions and litigation. So to sort of wrap it up, the theory is compelling, and obviously we have proved it to be helpful for almost 2 decades with considerable success. But to make it work, there is a critical element that's required. And this is important, I think, for all of us. Patent owners must genuinely and deeply trust their aggregator, for example, a patent pool. And the same is true with respect to the aggregator of potential licensees. That trust is hard to garner, and it takes a very, very long time and many transactions to achieve it. No patent owner in a pool and no potential implementer licensee is similarly situated with respect to other participants in a pool or a collective license. That's critical to know and critical to the kind of activities that an LNG might undertake. An intermediary must be in the middle of discussions among participating licensors and licensees to identify and fairly resolve those differences, the differences in arriving at a reasonable license price, while still maintaining pro-competitive behavior by both the licensor group and the licensee group. That's the essence of the formula that we all have to pursue. Without that intermediary that acts as an additional option for efficient resolution by, in our case, encouraging bilateral resolution as between patent holders and implementers, group boycott scenarios become a risk. A big difference to your question is that RPX is a principal in our transactions and does not act as an agent of either licensors or licensees. So RPX itself has discretion as to whether to proceed with any transaction. So RPX does not act as an LNG because the RPX model is pro-competitive and yields results when there are true efficiencies to be gained. This is the result of the trust that obviously we've established with licensors and with licensees over thousands of transactionally efficient resolutions. And this will, in my view, be a particularly challenging, for LNGs to establish just because they're new and they don't have the same track record that has taken us almost 20 years to establish. So, as I said, it's a tough road. Final comment. It is our view that governments worldwide should be mindful and cautious about intervening in patent licensing matters where the private sector is already demonstrating workable solutions to complex licensing matters, both with respect to SEPs and non-SEPs, particularly in the arena of government-mandated policies or regulations. I am certain that unintended consequences of actions will occur. Given our extensive and very successful experience, obviously, we'd welcome the opportunity to speak with both companies and governments about how to avoid regulations that will hinder rather than benefit the promotion of efficient resolution of patent disputes. I hope that answers your question.
It does, Dan, and thank you very much for the exhaustive answer. I mean, I have two key takeaways from what you have said. One thing, if I understand you correctly, is you avoid potential risks in your eyes that are associated with LNGs from an anti-competitiveness perspective, is that you compartmentalize your clients away from each other to prevent a possible collusion, and you act as an intermediary without a fiduciary duty to them.
I think that's exactly right.
And that you are identifying the risk that legitimizing LNGs could give rise to possible anti-competitive effects in terms of allowing them to exchange information and collude in order to suppress market dynamics and competitive pricing.
Yeah, I mean, it's always a risk because we every year we train every single person in the company with extensive, exhaustive antitrust guidelines under which we operate. Because let's face it, when you have competitors who are being impacted by the same patents, they obviously have, we'll just call it a curiosity about what is going on with respect to any given transaction relative to other market participants. And because we don't ever have to take a transaction within the company and work on it, and because we have an absolute obligation to remain pro-competitive, as I said, both with respect to licensors and with licensees, we have that ability to maintain that. And I think that the LNG will try and thread that needle But as I said, since every single company, both as a patent owner within the pool and with respect to implementers, they are all highly, highly different in terms of what their exposures may be, what their indemnities are, what other arrangements they have, and so on and so forth. And that is such an intricate, invasive kind of understanding that has to be dealt with, that it is, as I said, very hard to pull these things together.
Thanks, Dan. I'd like to go back to the pool side of the equation. And I have a question for Matteo, because in many ways I find CISVEL an interesting animal of its own making. You aren't just a patent pool administrator, you are also patent owners as well as patent pool members. For example, you license some of your patents via Avanti's 5G vehicle pool. As I mentioned earlier, you also have some group licensing deals with RPX's clients. Since CISVEL has multiple hats, both as a competitor and a partner to many parties it deals with, I'm curious to hear how you avoid or limit the potential anti-competitive outcomes in your dealings, which some people have alleged throughout some of the sessions that patent pools may be associated with.
Yeah, let me start with a little history of CISVEL to answer your first question as to why we're patent owners. CISVEL was founded in 1982 by our founder, Roberto Dini, who basically convinced Italian TV manufacturers who were faced with growing competition from Germany first and then Japan to pool their patents into what has become CISVEL, la Società Italiana per lo Sviluppo dell'Elettronica, to basically start monetizing the patents that were used by manufacturers outside of Italy. So in essence, CISVEL from its very beginning has been a patent owner. In addition, we're also quite unique as a pool administrator because we do have a very small company, small R&D arm, CISVEL Technology, that does develop technologies, especially in the video audio coding area. And so we have developed our own technologies, some of which have made it into some standards. And so we do own SEPs that were developed through our internal R&D. And yes, we do acquire patents. Now, the concept of a licensed administrator that pools patents by others, owning patents, is nothing new. In fact, the first incarnation of patent pools that were blessed by different antitrust authorities were exactly like that. There was one company owning patents that would basically take on the commitment to license its own patents and patents by others in a specific technology. So that's not a new concept. We are committed to pools. We are committed to patent pools, transparent patent pools for the pools that we administer, but also when we own technology that, there are pools out there on those technologies, we want to stay committed to the pools, and so we contribute those technologies to pools. We do acquire patents as well, and we see ourselves a bit like a clearinghouse for SEPs, in the sense that if there are SEPs on the market that could be contributed to pools, we think it's preferable for us to own them because of that commitment to the transparency and to pools than for others who might not be participating to pools. As to your question from a competition point of view, I beg to disagree. We're not in a competitive scenario with anybody really, because certainly we're not in a competition with our licensors, because we don't have a product business, so we don't compete downstream. We certainly do not compete upstream in the market of licensing patents, because again, SEPs are complementary, so we're not competing. And when it comes to deals, we take a very, very careful approach to compliance and antitrust compliance. We have internal processes that involve in-house and outside antitrust counsel, and we make sure to adhere to the most stringent antitrust regulations out there, which I would say are probably the guidelines by the European Union. There are differences in antitrust laws in different jurisdictions, but again, we take the approach of really going to the highest standard, and we do that in every deal. It's always a case-by-case approach, and I tend to advocate on a case-by-case approach also when when we deal with potential regulation at the EU level. I think from the antitrust point of view, first of all, regulation without a market failure is always to be avoided. And second, probably in antitrust and in other areas, a case-by-case approach is preferable to blanket regulation. If I may use another couple of minutes, our compliance processes have been basically confirmed by the recent draft TTG when it comes to the guidelines for pools. I think it's, the draft TTG, I don't know if anyone has read it because it came out last week, basically reaffirms the importance of patent pools first, and it strengthens, I think the previous panel briefly touched on it, strengthen the requirements for transparency and compliance. And it's a welcoming draft because it basically reaffirms concepts and processes that we are already implementing at CISVO. For example, participation is open, SEPs are disclosed, we have lists of patents that are disclosed, we show the methodology, obviously the license is non-exclusive, etc. I would point out that this compliance process is a burden for the patent administrator and for the patent owners. It's not free. It requires cost, it requires investment, it requires time. You need to declare your patents, you need to go through an external evaluation and have your patents evaluated, etc. And we do it because, again, we want to really strive for transparency. We've heard it in the deal-making panel yesterday that transparency can help speed up deals and close deals, and that's where we think we help. But again, it's a burden, and it's a burden that sometimes comes also with some potential drawbacks. One example is that by publishing patents on a website, then those patents are often attacked by some proxy like Unified Patents that try to invalidate patents. It's not uncommon for Unified Patents to pick patents from those lists and try to invalidate. It's most often than not a nuance because you just got to defend, but it's oftentimes Unified doesn't really succeed very, very consistently, but it's still a cost. So I want to remind everybody that we welcome the strengthening of those processes by the Commission, but those processes and those compliance processes come at a cost and are a burden for patent owners and pool administrators.
I was planning on going a different direction with the questions, but now I need to pick up on something you have mentioned, and I also see some questions coming in, if my colleagues could scroll one up. You mentioned that you welcome some of the new elements included in the Commission's tech transfer guidelines on the issue of patent pools. Particularly, I think you're mentioning, for the audience who doesn't know, the new tech transfer guidelines contains a requirement for patent pools to disclose the methodology used to verify essentiality and the results of the essentiality assessments in an effective manner to potential licensees. Now, different patent pools have different business models. Some patent pools already disclose their list of patents and the methodologies and the results of their essentiality assessments. Some do not. Maybe let's start this with John, but then I'm also, because Matteo addressed it a little bit on his end, I'd be also happy to hear from Uta about this.
So, not having analyzed everybody else's methodologies for evaluating essentiality, I can say, Access Advances pools, the licensors hire an independent evaluator or evaluators that we've designated. Those evaluators then evaluate the patents and identify which portions of the standards the claims apply to. And so you can find that on our website. You can see our patent list, and you can see the particular, for the claims, the particular sections of the standard that applies to. So in terms of transparency, I don't know what else would be required. I I saw the guidelines come out, and we're still evaluating them. But the initial read is, the way we operate. You can go on our website and you can see. You can get a copy of the list of licensors. You can get a copy of the list of licensees. For example, the HEVC patent pool has over 40 licensors and over 370 licensees. You can get copies of the license agreements on the patent pool. You get a copy of our rates so that you know what our rates are, which you can look at the rates by product and by region, based on different rates for the two regions. And then you can also see for each of our pools, there's a FRAND paper which discusses why the particular pool satisfies the requirements of FRAND. And so, my initial read, like Mateo's, was that the guidelines was very almost sort of codified the way we operate, but again, the devil's always in the details, and so we're still evaluating those.
Thanks, John. Let me turn to Uta on this, because I also see some questions on the screen. One person's asking, why is Avanci not publishing their list of patents? And there was another question right next to it. Should every patent being licensed by a pool like Avanci need to be tested for essentiality and validity, or would verifying only a representative subset suffice for licensing?
Indeed correct. Avanci does not publish indicative patent lists, but like many other joint licensing entities like patent pools, or also in bilateral licensing, we take a definitional approach to ensure that licensees have the broadest coverage possible. And what does that mean exactly? In Avanci 5G vehicle, for example, licensed patents are defined as all essential 2G, 3G, 4G, 5G patent claims owned or licensable by all the licensors during the applicable term of the license agreement. And that means all essential patent claims are covered, whether they form part of a list or not. And that also means, by definition, that not a single non-essential patent claim is part of the Avanci license. And frankly, for a quite comprehensive and very, very dynamic technology such as cellular, maintaining an up-to-date, comprehensive, and always accurate list of patents is simply not feasible. There are potentially tens of thousands of essential patent claims for 2G, 3G, 4G, and 5G, and new SEPs are granted to the more than 80 licensors participating in Avanci 5G vehicle every day. And on top of that, we have regularly joined new licensors as well. I think one aspect, again, from a practical perspective to keep in mind here, that in our experience, it is usually the case that a prospective Avanci licensee would discuss with us, as well as in parallel with one or more individual licensors, to assess what in fact would be the better option for them. And that is, coming back to competition law, a joint license is only ever an option, and it is an option, and it is non-exclusive. So it is up for the it's the prospective licensee's let's say job to determine what is the better option for them, whether it's an Avanci license or to go the bilateral way. And of course, in the bilateral negotiation, I would assume that if necessary, patent lists, claim charts, what have you, would be exchanged. And just to come back to the second part on the essentiality checks, I mean, of course, Avanci conducts essentiality checks. Over the years, we have conducted thousands of essentiality checks. For that purpose, we maintain a worldwide network of independent patent evaluators. They conduct the essentiality checks according to a process that we monitor very, very closely and maintain a quality control protocol for, in order to ensure consistency of results, of evaluation results across evaluators as well as jurisdictions. And I can assure you that it is, it's always in the interest of each individual licensor that Avanci has a very robust essentiality check system, because only then will the license be ultimately also be attractive to licensees.
You have said a few things that generated a lot of interest and a lot of question from audience, because I see the questions flooding in. Quite interesting. I'm going to pick two and quickly read it out, because they stand for the extreme opposite aspects. One says, how can licensees assess if Avanci rates are reasonable without knowing the patent list? And the other one says, on the one hand, licensees say they want to see the lists. On the other hand, they say they're not capable of understanding it. What is then the list good for? Which is quite a cynical way of approaching it. But I would like you to respond, and I see Matteo wants to respond to this as well.
No, just going to throw a pun. A former colleague of mine used to say that a successful patent pool is a patent pool that makes everyone equally unhappy. And so I think that that's sort of in line with what we're seeing on the screen.
Yes. And I mean, assessing the Avanci rate, and I think I quickly broached that at the very beginning in the first question, or my response to the first question that you had addressed to me. Avanci has a market-driven approach. We talk with individual prospective licensors as well as individual prospective licensees about what they would think a reasonable rate would be for the specific licensing equation. For example, 5G, 4G, 3G, and 2G for connected vehicles. And this is a process that often takes us quite a bit of time, but still, over the months, over the years, we start to see, a number where we think that can ultimately, for us, there emerges a number that we think ultimately is likely to gain wide acceptance by licensees as well as licensors. So it has nothing to do with a patent list, the number of patents on a list. It's about the value of the technology to, for example, a connected vehicle. Which is, in your case, for the 5G vehicle, if I recall correctly, $32 per unit. And we also offer a discount if you take a license before you sell your first 5G connected vehicle. And then I'm assuming you do engage in negotiations despite this indicative rate, in the sense that you don't negotiate the rate. We have the authority to license at $32 US / if you're eligible for the discount, $29 US. All right. So, because in the earlier panel we just heard some statements regarding what happens if the licensee has already licensed a certain part of the portfolio from the original licensor. That is a different matter. And of course, so-called double dipping is something that we do not condone in any way. And we work with licensors and licensees to assure that if there are any pre-existing licenses, that they are appropriately taken care of. All right. Just one quick question, just to tie it to the global economy panel we had today. If my colleague
colleagues could scroll up a little bit, are licenses by patent pools taken, are SMEs in developing countries like Brazil, India, South Africa, etc., taking licenses from patent pools? What percentage of the business goes to licensing in these jurisdictions?
So I'm not sure of the actual numbers, but I know that a significant portion of, for example, the Excess Advances HEC Advance Pool are by SMEs. And so, the patent pools actually, in my view, give SMEs significant advantages in the sense that it reduces transaction costs significantly. Small startup companies, developing companies, don't have the internal resources to negotiate potentially hundreds of contracts, and then in addition to negotiating them, maintaining them, and making sure you're doing the individual reporting requirements to each and every one of them. And so in my view, the patent pools actually assist SMEs in having access to the technologies. So some of the commentary, and again, I'm coming from the Access Advance Pool with the way we're set up. I think some of the comments were in terms of lack of transparency on rates, but our rates are also relatively readily available on the website. So.
Yeah, likewise, I can't comment on the exact percentage of SMEs, but throughout our programs, we've basically licensed companies in everywhere in the world, in any country that you can imagine, provided there is patent coverage, of course. I can only echo the fact that SMEs have a very simple way, one-stop shop to get a license through patent pools. I think probably one of the biggest advantage is that that the patent pool has a friend rate that is published on the website. It's transparent. That's the rate that is offered to everybody, so you know that you're getting the deal that everybody else is getting. I would add that at CISVL, we are currently exploring ways to further help SMEs, recognizing that especially for the IoT space, SMEs will be a growing percentage of the implementers side, and we think that there are potentially solutions that can simplify even further the licensing for SMEs. Again, we're still discussing internally and brainstorming as to what exact solution could work, but we recognize that for SMEs there could be an extra step made.
Yeah, and I can only agree with John and Matteo. I think joint licensing platforms and patent pools are extremely beneficial, especially for SMEs, because they do offer a license on the same terms and conditions as they would also be offered to their often much larger competitors. And from a previous panel, we have understood that that is one of the major concerns for smaller enterprises, that they feel that they may not get as good a deal as larger companies in bilateral licensing.
If I could just add one last thing. I think we often forget about the innovative SMEs. In the SME panel, we had one innovative SME, but in the debate, especially with regulator, that aspect gets sometimes forgotten, that there are SMEs on the implementer side, there are SMEs on the innovator side, or in between. And pools are extremely useful for SMEs also on the innovative side, because it gives basically an option for licensing in areas where an SME might not have the ability to, the bandwidth, the expertise, etc.
In one of the panels earlier today, I think it was the SME panel, there was this talk of the SCP bubble, and that if you're not in the bubble, information is inaccessible or difficult to understand, which makes me want to ask John a question. Since, John, you started as Chief Legal Counsel at Access Advance earlier this year, after 5 years at Walmart as legal counsel. Now, as we know, Walmart exists in a different IP universe, or that's what we usually think from outside in terms of its line of business. So what do you see as a major challenge from your current perspective that sets it apart from your past experiences in IP licensing and dispute settlement, given the unique nature of patent pools such as Access Advance and their role in SEP licensing?
So I think that the thing that this role is markedly different vis-a-vis patent pools than my prior roles, because at Walmart, I ran Walmart's patent litigation. Before that, I was in private practice litigating patents at Jones Day and DLA Piper, often standards litigation. Even Walmart was involved in some standards litigation when I was there. The biggest difference for me is as an administrator, we don't own the pools, and as a litigator, I don't own the patents. As a litigator, I am we're already at the point where there's a fight, and here the goal is not to litigate. The goal is to help the licensees get the technology that they need to do to be able to develop their product and market their products, while still rewarding the licensors for the investment that they've made into the technology. And so it's like I think Matteo said, you're a successful pool when both sides are just a little bit unhappy, and that's part of managing that dynamic is probably the biggest difference for me.
Thank you. We are slightly over time, but I just want to finish with a rapid round of answers to a question that I hope is rather straightforward, because today in the SME panel we heard from Jacob the story of Rabbit and the Fox in Australia, and the need for prudence in regulation and government intervention. So in that sense, I would like to ask to all of the panelists, is there a market failure that necessitates intervention right now?
No, I think we have seen licensing platforms and patent pools flourish over the past few years. I think they're a very simple and efficient way to share technologies between different industry sectors. And to piggyback on what Peter on the previous panel said about Schubert Lieder, I picked Du bist die Ruhe, you are the quiet. And I think licensing platforms and patent pools can contribute to that, and there's no need for regulation.
Thanks, Matteo.
I'm of the same opinion. I want to maybe briefly, people might remember in this room the Draghi report. They came out exactly a year and a few days ago. That report basically analyzed the level of competitiveness and investments in Europe. In the occasion of the first anniversary of the Draghi report, Draghi went back to Brussels and spoke in front of the parliament and said a lot of things. But one thing that he said was there are 3 areas where more ambition is needed. First, removing barriers to scale up new technologies. And that's exactly where industry solutions like pools have been successful in doing that, in providing access to technologies so that the European industry and the global industry can flourish. And instead, sometimes we see regulators got to regulate, I guess. So proposing regulation where there is no need for regulation and there is no market failure.
John, is there a market failure that needs to be addressed?
I certainly don't think so. I think as one of the panelists, and I forget who it was, said at the IAM summit in London earlier this week, is there anything more friend than a pool? I mean, it may not be perfect. I mean, you can always find issues, because you're never going to please everybody. But if everybody's a little bit unhappy, I think you've found the recipe for success. And so, we've got at least 30 years of jurisprudence on SEP pools, and so I don't think there's a need to throw a monkey wrench into the system just for the sake of change.
Dan, now let's make the rounds back to you. Since you work with licensees on a regular basis and implementers, is there a market failure which requires regulatory intervention?
As I said in my earlier remarks, the answer is no. I mean, the one thing that everyone, of course, needs to remember is that patents are an unusual animal. they are a negative right. The only thing a patent does is give the patent holder the ability to keep someone else from practicing. So it is inevitably controversial. And as long as we all stay focused on finding the most efficient ways of dealing with the realities that come with patents, then there is no market failure. And I think that the market has demonstrated that while it may not be the most efficient mechanisms that have been developed, it is much more likely that the private sector will successfully continue to drive these efficiencies, and that government intervention is only more likely to slow it down because there will be unintended consequences. And no one can predict exactly what they will be, but we can predict they will occur.
Thank you, Dan, and thank you to all the panelists. I think this brings us to the end of the session. We are 5 minutes, too many, but I think this was a very good session. So let's wrap it up here. Our hungry and tired audience can be united with their lunches, and I hope we didn't bore you too much with our session. I hope we kept you active, alive, and interested. Thank you all very much.
Thank you very much.
The hungry and tired audience also needs to be fast, because food will only be served until 2:30 in the cafeteria. You will have time to eat it after. You don't have to leave until 2:30, but be quick to actually get food. Bon appétit.